Professionalism concept. Exemplar, legal issue. Types of nursing malpractice, medication error, failure to follow a physician's orders, delay in patient care and or failure to monitor a patient, incorrectly performing a procedure, or trying to perform a procedure without training. Documentation error, failure to get informed patient consent. Legal issues. In nursing, legal issues encompass the rights, responsibilities, and scope of nursing practice as defined by state nurse practice acts NPA and as legislated through criminal and civil laws. Clients have the right to expect competent nursing services. They have the right to a nurse that has the right education and knows how to use it. Many healthcare organizations have policies and procedures in place to minimize the risk of error resulting in adverse events due to accident, carelessness, system failures, or malpractice. The policies that the hospital comes up with are there to guide your practice so that you don't get into legal trouble with patients later. Unintentional torts, negligence and malpractice. Tort law defines and addresses unintentional and intentional actions or omissions that result in harm to another person or harm to another's personal property. One way that this can happen is through negligence. Conduct that deviates from what a reasonable person would do in a particular circumstance. A driver who's talking on their cell phone and blows through a stop sign and hits another car, that's through negligence. They shouldn't have been on their cell phone. They weren't paying attention when something bad has happened. An individual who undertakes a particular activity is considered to have the appropriate knowledge to engage in that activity. The car driver knows that he has to pay attention, and by not paying attention while driving, negligence has occurred. Your patient's O2 set alarm continues to go off. You shut off the alarm now. Let's say you've left the room and the patient pulls off their oxygen. You don't have an O2 stat alarm to go off, so you don't know that the patient is desatting. That mean example of negligence. A negligent act occurs when an individual damages the person or property of another without any intent to injure. You didn't mean for the patient to desaturate, but because of the negligence of shutting off the alarm, that's what happened. Unintentional torts, negligence and malpractice. Malpractice, conduct that deviates from the standard of practice dictated by a profession. Malpractice, conduct that deviates from the standard of practice dictated by a profession. A nurse playing on their cell phone at work instead of paying attention, that could be a deviation from the standard of practice. If you have policies in place that say that cell phones aren't allowed in the patient care area, malpractice could also be an example of negligence that result in malpractice, including failure to follow standards of care, so not following what the hospital says. Examples of negligence that result in malpractice include failure to follow standards of care, If you're supposed to check a patient's wristband before you give medication and verify their name and date of birth, if you don't do that and you give the medication to the wrong patient, that could be a malpractice suit. Fail to use equipment in a responsible manner. Communicate, document, assess and monitor important patient information. Incorrectly shutting off your alarms. Act as a patient advocate. If you know a patient doesn't want a procedure done and you're supposed to witness the consent and you know that the doctor did not ask them, you could be liable for malpractice. Follow the chain of command. If a resident makes the wrong call and you know it's a bad call but you don't go to the attending about it, that could be a sign of malpractice because you didn't follow the chain of command. In our hospital we have the chain of command written all over the unit. You start with the resident, you go to the attending, and you go to the chair of the department. It goes all the way up to the chief medical officer. So failure to follow that chain of command, if you know you're not, that the team is not doing right by the patient, can result in liability towards the nurse. Informed consent, liability, refers to the client's legal and ethical rights to be informed of, and give or refuse permission for, any healthcare procedure or treatment. Give or If a patient comes in and you want to take their blood pressure but they do not want their blood pressure taken and they do not give informed consent does not have to be written all the time. There is verbal consent or expressed consent. You cannot force a patient to get any kind of treatment if they're in their right state of mind. If you're going to do a procedure on a patient, such as the doctor is going to do a bronchoscopy or they're going to have a lumbar puncture, then a written informed consent is needed that is filled out by the patient and the doctor, and in that conformed consent, the patient has to know about what's going to happen to them during that procedure. What are the risks of the procedure? What are the risks if they don't get the procedure? What are the benefits of the procedure? Information is provided in terms that a client can understand, with available alternatives being disclosed. If a client is Spanish speaking only and you hand them a consent in English, you have to have an interpreter who has been trained in medical terminology to go over the informed consent form with them using a family member. If a client is Spanish speaking only and you hand them a consent in English, you have to have an interpreter who has been trained in medical terminology to go over the informed consent form with them using a family member. Using another staff member who has not gone through the training does not count as informed consent. It has to be somebody that the hospital is hired to translate, because we have texts that speak Portuguese and speak Spanish, but they weren't trained in medical jargon, so they may not know how to explain everything to a patient, and you would have no way of knowing if you don't speak the language. So to give the patient the most informed consent, it has to be somebody who is trained to do risks and benefits of each treatment option, and the client's right to refuse treatment. So if the doctor goes through all of the treatment options and this is not something that the patient wants and they do not sign the informed consent, that is their right. They cannot be coerced or bullied into getting it. Even if the physician or the nurse thinks it's the right thing for the patient has to think it's the right thing for them. Informed consent. Nurses should follow their employing agency's specific protocol regarding informed consent. Expressed or implied consent. Like blood pressure cuffs and vital signs, a patient can refuse anything when they're in the hospital, any kind of treatment that they don't want, and you cannot force them into it, or you are in the wrong. Expressed would be if they told you, no, I do not want that done, or yes, I want that done. Implied consent would be if they pushed you away when you tried to take their blood pressure. That would be implied that they do not give consent. If they position themselves, let's say for a lumbar puncture, and they're participating in it, that could be implied consent, but they also need the written informed consent because it's a procedure. So I know that can be confusing. So for minor things that don't need a written consent, they do need to give expressed or implied consent, and for any kind of procedures you need written consent. Factors for consent include competency, emergency care, and child participation in healthcare decisions. Competency meaning the person has to be of the right mind. They can't be under the influence of, let's say, fentanyl or morphine. They can't have a debilitating brain injury or learning disability, so they have to be able to be competent enough to make this decision for themselves. If not, then a proxy would be assigned to time for a guardian. Emergency care, let's say a patient comes in and they were in a horrible car accident and they are unable to give consent, and there's no family around, cause they were the only one in the car. The doctor can make that emergency decision. The care needs to be given to save that person's life. And child participation in healthcare decisions under the age of 18 in most states, an adult, a guardian, either a mother, father, or legal guardian, has to sign consent for them, but that does not mean that a child shouldn't be part of the consent process. So, case scenarios read through each scenario, determined if informed consent has been obtained legally. 10-minute activity. A Spanish-speaking client is having a total hip replacement. Anesthesia is having the patient's daughter translate the information. No, should be someone who is unbiased that was hired by the hospital to translate. You are getting a patient ready to go to the OR based on the questions the client is asking you. You feel that the patient is not aware of the risks of the procedure. No, then they were not given all the information that they need. Now sometimes through fear patients will forget, so a gentle reminder, but also you might want to dig into it more. Was that discussed when the doctor went over it with you? So this is important because if later something happens and the patient comes back and says, you never told me, that you could also be liable. A nurse listens to a physician obtain consent for a procedure over the phone for an unconscious client with the healthcare proxy. The nurse signs the consent form as a witness. Yes. This is obtained legally. You can get phone informed consent or informed consent over the phone. The doctor has to go over all of the risks, all of the same stuff they would as if the healthcare proxy was right there in front of them, but it has to be witnessed by someone such as a nurse or another doctor, and then the nurse will talk to the person on the phone and say, do you understand all the risks, the benefits, and what the procedure is? It's another time for them to ask questions. If they say they understand, then you sign the informed consent as a witness. The client has just signed his consent form 15 minutes after you administer fentanyl to the patient. No, the patient is under the influence of fentanyl, which is mind-altering, so it would not hold up in court that they signed under their right mind, and the client signed a consent for a percutaneous interventional procedure, PCI. The patient is asking you different questions about the procedure, such as how he will be positioned and does it hurt? Yes. I would definitely dig in for more information. I would not put anything on the test that was this vague. Those things should have been gone over when they got informed consent. So probably not, but again, the patient may have been very anxious, so maybe they don't remember what was said. These things are pretty benign. They're not as bad as the risks and adverse events that could happen. So, yes, this was probably obtained legally.